Hello, Michigan Realtors, and welcome back to Letter of the Law. Today, based on several emails asking for it, we are diving into a very important topic. We call this installment, All Inspection Clauses Are Not Equal. If we compared the various Realtors buy and sell forms used throughout the state, it is likely the case that no two inspection clauses are exactly the same. Every agent in your office must understand this fact, and if they receive an offer on a form other than the one they typically use, they must be very careful to follow the inspection process outlined in that particular form. There are no rules of thumb as to how inspection clauses must work. Some of the differences between inspection clauses include some forms allow a buyer to conduct whatever inspections they choose. Others require the buyer to agree in advance as to what inspections will take place. Some forms allow the seller to terminate the purchase agreement if the buyer submits any request for concessions, while other forms say that if the seller does not agree, the buyer then has an opportunity to withdraw their objection and close. Sometimes the buyer's right to withdraw their objections depends on whether the inspection period has expired. And sometimes, if a party does not respond within an allotted time period, the transaction proceeds forward. Other times, silence can result in a termination of the purchase agreement. Some forms allow a buyer to terminate by simply providing a notification that the inspection is unacceptable, while other forms require the buyer to be specific as to their objections and/or provide written evidence as to the defects. Some forms provide that the buyer may only terminate the purchase agreement if a particular defect is material and/or the combination of the defects is material. And lastly, some forms try to limit the buyer's options. For example, there are forms that say if the buyer finds the inspection to be unsatisfactory, the buyer can either terminate the purchase agreement or request that the seller correct the defect, but presumably cannot request a price adjustment. What is sufficient notice? Most, perhaps all, inspection clauses require a buyer to provide notice in writing. We've received a number of questions as to what type of writing is required. Must the writing be a formal addendum to the purchase agreement, or will an email or text suffice? What about an email or text from the buyer's agent rather than from the buyers themselves? It seems unlikely that a court would hold that notice requires an actual proposed addendum signed by the buyer. That is certainly a best practice, but that does not mean that anything short of that will be deemed insufficient. It would seem to be the case that most judges would find any writing, on paper or electronic, from the buyers to be sufficient. Obviously, if the contract contains a specific provision discussing how notices will be handled, that process should be followed. But what about an email from the buyer's agent to the listing agent? Suppose, for example, the buyer's agent sends an email to the listing agent stating that my client is waiving the inspection contingency. Since the buyers themselves did not provide the notice, can the buyers later change their minds? Similarly, what if the inspection clause allows the seller to terminate the contract if the buyers make a concession request? If the request comes from the buyer's agent rather than the buyer, does the seller still have the right to terminate the purchase contract? Again, best practices dictate that the buyer's agent should always have the buyers themselves sign any required written notice. But buyers' agents should not assume that they can provide informal notice on behalf of their buyer client without committing their client in any way. There is a legal doctrine, the doctrine of apparent authority, where under some circumstances, a buyer will be deemed bound by the acts of the buyer's agent. Under this doctrine, the question is whether a person familiar with the nature of a particular business would believe that the agent had such authority. Obviously, this is a very subjective test. Suppose that the purchase contract gives the seller the right to terminate if the buyer requests concessions. Under the apparent authority doctrine, if the buyer's agent rather than the buyer provides written notice asking for concessions, one could argue that it was reasonable for the seller to believe that the buyer's agent was speaking on behalf of his or her client, and therefore the seller had the right to terminate the contract. At a minimum, it is a viable legal argument that could result in a costly lawsuit. A note on for informational-only inspections. Informational-only inspections have become more and more common. Buyers agreeing to an informational-only inspection often say something like, well, that just means I won't ask for the seller to make any repairs. If it is a big ticket item, I'll just walk away from the deal. Now, legally, that is simply incorrect and very dangerous. By agreeing to an informational-only inspection, the buyer is agreeing to buy the property regardless of what the inspection uncovers. If the buyer walks based on the discovery of a major defect, the buyer will be in breach of contract and be liable to pay the seller damages. Now, damages are typically the difference between what the buyer agreed to pay for the home and what it is worth. Obviously, the bigger the defect, the more likely it is that the buyer agreed to pay more for the home than what it is worth. But buyer's agents should take very good care and make sure that their buyer clients clearly understand the ramifications of an informational-only inspection. We have revised the acknowledgement and release form that we provided last year to cover informational-only inspections. If what the buyer really wants is the right to walk away in the case of a big-ticket defect, then the clause needs to be written that way. For example, buyer's offer is contingent upon a satisfactory inspection at buyer's expense within X amount of days, provided, however, that buyer may not terminate this agreement based on the results of the inspection unless it reveals a single defect, the estimated repair cost for which is in excess of blank amount. Termination requires written notice of termination from buyer to seller, together with a copy of the inspection upon which the buyer relies. Thank you so much for tuning in, and as the kids say, don't forget to subscribe to this YouTube channel. Please keep those suggestions coming to the email below, and until then, we'll see you next time.